The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes, the Supreme Court of North Carolina has resumed sitting for the dispatch of business. God save the state and this honorable court.
Good afternoon, everyone. Our next case is State versus Hilton. We'll hear from the appellant.
Mr. Chief Justice, Associate Justices, may it please the court. My name is Joe Finarelli, here on behalf of the state of North Carolina, and I'm here to argue that the majority below erred because it failed to recognize the distinctions between the circumstances presented to it by this defendant and those this court addressed in the Grady 3 case, the most recent of the Grady opinions, and therefore the court below erred in reversing the trial court's decision that defendant's lifetime enrollment in the SBM program was reasonable. As the court well knows, its holding in the Grady case, while somewhat broad given the facial aspects of that holding, is expressly narrow. And the court, on multiple occasions in the opinion, limited that holding to a group of unsupervised offenders, those who had no ongoing supervision with the state, whether incarceration, probation, or post-release supervision. Those who were on the SBM program only because they were a recidivist offender, and those who had not committed an aggravated offense, had been designated a sexually violent predator, or had committed statutory rape or statutory sex offense, the two offenses that the General Assembly subsequently had said required lifetime monitoring. In its analysis, the Grady 3 majority walks through the totality of the circumstances test, balancing the intrusiveness of the search of Mr. Grady in that case against the nature and purpose of the search and the governmental interests that are implicated by that search. But there are several factors in this case that make the circumstances quite distinctly different from those that the court addressed in Grady. Here, Mr. Hilton is an aggravated offender. He is not a recidivist. He is not on SBM solely because of a designation as a recidivist. He committed first-degree rape back in and was convicted in 2005, and he was ordered by Judge Keenert below to register and to enroll in the satellite-based monitoring program as an aggravated offender on the basis of that conviction. He's also, as for the second factor, he's committed an aggravated offense. So not only is he not solely a recidivist, although as we point out in the brief, I think he would qualify as that now, that was not finalized before the trial court made its ruling. In addition, Mr. Hilton remains on post-release supervision because of the subsequent conviction for taking indecent liberties. Looking at the Department of Public Safety's website, he is slated to be on post-release supervision until about 3 years from now exactly, May the 26th of 2024. So for those reasons, Hilton alone falls outside of the specific holding of the Grady case. Now, clearly, the courts in light of Grady have analyzed various scenarios of satellite-based monitoring for different combinations of offenders, those who have terms of years, those who are currently incarcerated. And in the process of doing that, they are applying to the best they can this court's opinion in Grady 3, and at least the analytical framework that the panels in the Court of Appeals reference. In this case, the panel below was no different. Where I think the problems occur is in discussing the record, or in considering the Grady 3 opinion and the majority's holding. The courts, and this case was no different, are forgetting that you need to look at the totality of the circumstances before this court, before the panel below. not incorporating some of the language from Justice Earle's majority opinion that addressed a different record, a different set of circumstances, and a different defendant. So what the majority did here, they relying in and following, I think, the expectation of privacy prong of the analysis, looked at what this court said in Grady 3 and discussed that the expectations of privacy are lower generally for offenders who are committed or who are convicted of felonies, but are in particularly diminished for those offenders who are on some sort of state supervision, in this case, post-release supervision. So in that sense, the panel below decided that while it was unreasonable in light of the discussion in Grady for Mr. Hilton to be enrolled in satellite-based monitoring for life, it shortened the time frame to the period of post-release supervision. And we contend that that's a problem because it really isn't taking into account the factors that were before this court, what the trial court found, the circumstances of Mr. Hilton's offenses, and the circumstances of his post-release conduct, not just the allegation at the time of the charges that led to his subsequent conviction for taking indecent liberties. But
so is it in essence your argument with respect to the portion of the trial court of the Court of Appeals decision that deals with the post-release supervision phase of the defendant's period of satellite-based monitoring, that the trial court, if you look at the trial court's findings in this case, they are sufficient to show, one, the necessary diminished expectation of privacy coupled with a sufficient showing of efficacy?
Yes, as the appellant, my argument is exactly that.
I'm having, I don't know how to, I'm not doing a very good job of asking my questions in such a way that I'm differentiating your posture before us, but thank you.
Understood. And because in maybe 15 minutes, well, after Mr. Grant finishes, I'm going to be getting up and making a different argument as the appellee. Right. As the appellant, we are asserting that there are sufficient circumstances here, given the diminished expectations of privacy, not only for the period of post-release supervision, but we would argue that even if, and I can't say even if, with the expectations diminished as this court found in Grady for those who have completed the period of post-release supervision, that even with those expectations of privacy restored, there are still circumstances that warrant the imposition of lifetime satellite-based monitoring.
Do you challenge the severability of the for life clause as something that is available to the Court of Appeals, or are you just saying that the severability should not have applied in this case?
Let me answer that because, again, I'm wearing two different hats in the course of the appeal. I don't believe that it was necessary to sever the for life portion of the statute in question. I do believe, though, when I'm arguing in rebuttal and in response to what I expect Mr. Grant's arguments to be, that even if the court had to resort to severing the for life language, it is not a problem and does not offend the Constitution or the legislative purpose behind that particular statutory provision. So I know that may not be the clear, direct answer you wanted, but as far as the purpose of this argument on appeal as the appellant, yes, we are arguing that the severability was not required. It was enough under the statute as written to find that this enrollment for Mr. Hilton's lifetime was reasonable.
Yeah, the Court of Appeals took the position that it could sever the for life aspect of it because it did not find unconstitutional the full framework of SBM. So just for the clarity's sake, you're just riveting your challenge of for life, as that phrase is used, to this case alone and this defendant.
Yes, we're not taking a position that that was appropriate for the court to do. We're just saying that in this case, it was unnecessary for the court to have done that. When we get to the part of the argument where I'm the appellee responding to Mr. Grant, I'm sure there will be questions about that severability that I may be able to address your question more directly, Justice Morgan. But we are saying that the statute as written, without amendment or excision, would still have justified, the circumstances would have justified lifetime SBM enrollment without severing anything from the language. So
I think my question applies to you as appellant, and what I want to understand is, and I understand the original hearing in this case was am I correct? It was before the decision in Grady 3, the original
Yes.
hearing. But was there any evidence, turning to the prong of the analysis that asks whether the satellite-based monitoring actually serves the government's legitimate interest, so the efficacy of the program, was there any evidence in this case separate and distinct from the type of evidence that was advanced in Grady?
that shows the efficacy globally? No. And I believe what we pointed out in the brief and what the trial court would have relied on for that purpose was the fact that the testimony from the probation officer that had he known that, because had Mr. Hilton been on satellite-based monitoring, there would have been an alert that Mr. Hilton was traveling to places he should not have gone, and that they could then have restricted his access or at least prevented potentially the offense that was committed in the taking indecent liberties charge that followed the SBM hearing. As far as, are there studies or factual data that support or that were presented to the trial court that demonstrate satellite-based monitoring works for either preventing crime or solving crime? No. In all candor, that there was no evidence on that point directly, just the indirect suggestion that I had mentioned. So we're balancing, and the court is required, as it knows, to balance both the expectations of privacy and the nature and purpose of the search. One of the things that I think was pointed out by you, Justice Earls, in your majority in the Grady 3 case was the statement that was made by counsel at the argument there that the purpose of SBM was simply to solve crimes. And you cited in the opinion to portions of the statute, I think, that would suggest that as a purpose. I would argue, however, that that is not the exclusive purpose of the statute, and I think the statute reflects that as well. In 14208.5, the legislature talks about the need for, in that entire chapter, or I'm sorry, in that entire article, of protecting the public. And I think that if we're trying to suggest that the only focus of that legislation is to solve crimes, that isn't really protecting the public. Clearly, there are aspects of the policy and the statutes that talk about collection of data and correlating it with crime events for purposes of using that data to either exculpate or inculpate certain offenders. But that isn't the only purpose of the statute. And I think that if the purpose is preventing future crime, then I think the balance strikes a little bit differently. Clearly, it is within this court's purview to determine where to strike that balance. But I do think that the Grady opinion too narrowly focuses on that particular purpose when there are alternative purposes. And the majority below sort of latched on to the protection of the public idea by saying, as I was mentioning before, the potential for the probation officer to have been alerted to Mr. Hilton traveling to a county he was not supposed to go to without permission, and then in having that reported to the parole commission to potentially put him on satellite-based monitoring. I can't explain why he was not on satellite-based monitoring to begin with. I don't know whether that was an oversight by the parole commission or whether I'm misreading the statute, but I believe, based on the conviction for Mr. Hilton in 2005, that he would have been or should have been on satellite-based monitoring anyway as a condition, as a mandatory condition of his post-release supervision. So because of the circumstances here, there is additional evidence as far as the nature and purpose of the search that was not before the court in Grady. There is certainly evidence about Mr. Hilton himself that differs from the evidence this court considered about Mr. Grady in his circumstances that we believe permits the court to affirm the decision essentially of the trial court and reverse the decision of the Court of Appeals that lifetime satellite-based monitoring was reasonable under the Fourth Amendment. Unless there are other questions at this stage, I would like to reserve my remaining time for rebuttal, since I know there is likely robust argument on the other side. Thank you.
Thank you, counsel. We'll hear from the FLE.
Thank you, Chief Justice Newby. Good afternoon, Your Honors. May it please the court, Jim Grant with the Office of the Appellate Defender on behalf of Mr. Hilton. So as Mr. Finarelli discussed, there are basically two broad issues in this case: the constitutionality of the search during the period of post-release, and then the constitutionality of the search beyond the period of post-release. The only disagreement among the panel was as to that first question, but really it's the second question that is the big issue in this case. As Mr. Finarelli noted, Mr. Hilton will be on post-release for another 2 years and change, and then after that he'll be subject to a lifetime SBM order. The vast majority of this order concerns monitoring while Mr. Hilton is not under any sort of post-release supervision. And as to the bulk of this lifetime order, this big question, there is no meaningful distinction between this case and Grady 3. Stare decisis answers the big question in this case. All of the several constitutional defects with the current satellite-based monitoring regime this court identified in Grady 3 are present here. Here just in Grady 3.
Is it your opinion that the nature of the offense doesn't matter? In other words, the General Assembly has created 4 categories, one of which was recidivism, but the others have to do with offenses that in the public policy consideration by the General Assembly, they determined to be more egregious. Is it your position that regardless of the crime, that is not a consideration?
I think it's our position that regardless of the lifetime category that any particular defendant falls into, that the problems that persist in these cases and persist in this record, as every record that has come before, or at least most of the records that have come before the Court of Appeals and certainly this court, you have the same issues irrespective of what class it is. You have a lifetime search, which this court has said is not punishment, but nevertheless imposes a significant intrusion into a defendant's liberty interest, is imposed automatically by statute, regardless of what category, with no judicial review mechanism, for life, and perhaps most importantly, without any evidence of efficacy that this program actually does anything.
Why is it not the role of the General Assembly to determine a public policy with regard to efficacy?
Well, I think it's the role of the General Assembly to legislate, and it's the role of this court to determine whether that legislation is constitutional. And Grady 3 stands for the proposition that the current program, particularly when the state does not present any evidence of efficacy, which is required. It's one half of the balancing test this court must engage in order to determine whether the search is constitutional. When there's no evidence of that efficacy that the state presents, the search can't possibly be constitutional because there's nothing to weigh on one side of the balancing. And, you know, I think our position would be that any legislative finding of efficacy still needs to stand up to factual scrutiny. And that's not just our position. That's in fact what Grady 3 says.
Well, isn't that also, or hasn't the U.S. Supreme Court also made statements with regard to recidivism and the dangers of recidivism with regard to violent sexual offenders?
I'm sorry, Justice Newby, what's your, Chief Justice Newby, what your question is, did the Grady 3 majority make findings about?
No, I said the U.S. Supreme Court. Hasn't the U.S. Supreme Court in various cases made statements with regard to the recidivism of violent sexual offenders, particularly child sexual offenders, and the damage, the injury that's caused?
Oh, for sure, there are statements in U.S. Supreme Court opinions to that extent. I think you're referencing in particular Alaska v. Doe or Doe versus Alaska, where I believe it was Justice Kennedy said something to the effect of sex offender recidivism rates are frightening and high, or some such language. It turns out, and at the risk, I don't want to talk about things that are not in this record because there's no data, the state presented no data about that one way or another in this case. But I am aware of studies that suggest that that's not actually correct. So the point, overarching point.
If the state then has to present efficacy evidence, that would be true in every single satellite-based monitoring case, right?
Yes, if the defendant makes an as-applied challenge.
It seems to me that, again, why can't the General Assembly, in crafting public policy, make that kind of determination, and our role then simply to be based on the General Assembly's policies? Is this an unreasonable search given their findings?
Well, that issue was alive in Grady 3, and this court concluded that you know, I'm aware of the vote breakdown in Grady 3, Chief Justice Newby, and that the majority held that there was an independent requirement for the state to demonstrate evidence of efficacy, and we can't presume that just because the General Assembly passed a statute, that statute actually accomplishes the purported interest it seeks to advance, that the state bears a burden. Just because it is conceptually possible that satellite-based monitoring could be effective doesn't mean that it is so, and it is the state, not the defendant, who bears the burden of demonstrating that it actually accomplishes the legitimate interest.
Well, if your reading of Grady were correct, why didn't the majority strike facially the statute that requires lifetime satellite-based monitoring?
Well, I think that there are questions of jurisprudential prudence in terms of just addressing the issue that is before the court, or just at minimum, the particular class of offenders that is before the court. I mean, frankly, Chief Justice Newby, I think this court could have very well held that the entire regime was unconstitutional.
So let's talk about the review process. So under the statute, it's reviewed by the basically the parole commission, correct?
You're talking about for the lifetime offenders, there's the parole commission procedure, yes.
And that can occur after 1 year, correct?
1 year after the termination of any supervision or sentence.
So, you know, obviously we had this discussion with your colleagues in the prior argument. Why is it, since this is a civil action, why could the defendant not bring an action in the cause if, in fact, the defendant was denied by the parole commission to show changed circumstances, to show that despite the gravity of the offenses that he has committed, that he should not longer be subject to satellite-based monitoring?
Well, I think there are a few problems there. The first is it sort of confuses the procedural posture that these cases are in. The state is the movant in these cases. It is the state that is seeking a remedy. The state is seeking to impose satellite-based monitoring on a defendant pursuant to the statute. The state has a burden it must bear. If the state doesn't meet its burden, then the court can't enter an order imposing the search constitutionally. And furthermore, the post-release commission procedure is only available in lifetime cases. So there's a whole section of SBM that wouldn't even have that remedy. But in a case like this, where that remedy does exist, the parole commission, and I think Mr. Wimmer-Dieter said this in the previous argument, it's basically an act of executive grace, and there are no standards that apply to that. I would assume that the standard of review in that would be abuse of discretion. And furthermore, there's no procedure for the parole commission to evaluate the actual question at issue, which is this a Fourth Amendment search that is reasonable? I mean, that is the issue. That is a separate question from sort of as a matter of prudence, should this person be monitored or not monitored? That's almost, I mean, that's sort of the fundamental legislative question, but that's a separate question from the constitutional matter, which is properly before this court in this appeal.
But the question is lifetime. And the argument is it is the lifetime portion, not the actual satellite-based monitoring itself, but the lifetime aspect that tilts the balance in favor of unreasonable. So if we're looking at that aspect, why can we not consider the potential civil remedy as well as the remedy under the statute?
I mean, I wouldn't concede that the issue is the lifetime aspect. I mean, I think and I certainly wouldn't concede that while on post-release, it's a reasonable search, although I would note, and I think Mr. Finarelli noted, that it is a mandatory condition of sex offender post-release to have satellite-based monitoring regardless of the entry of any order. But I think more fundamentally, you have a second of monitoring is unconstitutional. I mean, this is a perpetual search. Our argument is not, I mean, part of our argument is this goes on for life and that is problematic from a constitutional perspective. But every second, I mean, Mr. Hilton is currently being unconstitutionally monitored.
So your position is satellite-based monitoring is unconstitutional under every circumstance?
Our position is that satellite-based monitoring, in this case, our position is that satellite-based monitoring is unconstitutional in this case, where the state failed to present any evidence of efficacy, and the contours of the program are really no different than they were in the Grady 3 case. And to the state's credit, the state doesn't ask this court to reverse Grady 3. What the state does is tries to force distinctions between this case and Grady 3 that unfortunately for the state are just not significant. The state notes that Grady 3 was limited just to recidivists, but as this court noted, rather as the dissent noted in Grady 3, the rationale is the same. In sort of almost prophetic fashion, the dissent said at some point, this rationale could be used to invalidate all of the lifetime categories as unconstitutional. And frankly, that case is here now. There is no distinction between the contours of the program in Grady 3 and the nature of the state showing.
So your position is lifetime satellite-based monitoring is always unconstitutional.
Again, our position in this case, Chief Justice Newby, is that when the state fails to demonstrate efficacy and the contour of the program is the same as it is in all of these cases in terms of the nature of the monitoring equipment, et cetera, and certainly the same as it was in Grady 3, that Grady 3 stands for the proposition that satellite-based monitoring is unconstitutional in this case. That would be our position.
Well, let me ask it a different way. If this is simply an as-applied challenge, how is it unconstitutional as to your client, and yet the statute itself would survive?
Well, I think this gets into the way that Grady 3 is sort of is written. It's something of a hybrid between a facial and an as-applied challenge.
So at least you agree with part of the dissent.
I do agree with that portion of the set, Chief Justice Newby. I think that it is an interesting way in which the majority is written to where clearly it's holding SBM unconstitutional as applied to Tory Grady, but then goes on to say anyone basically similarly situated to Tory Grady in terms of being within the narrow recidivist class also gets relief. I think in fact the court used the phrase injunction. This court has enjoined enforcement of the SBM statutes against all people in the Grady class. And I suppose our position, Chief Justice Newby, is that this is now the case where the court recognizes what the dissent in Grady 3 recognized, which is that logic really applies to any case in a lifetime category where the state fails to make a showing of efficacy. And I think humbly that is basically our argument, is that this issue was decided a year and a half ago in Grady 3, and this is the case where stare decisis dictates a particular result.
Are you challenging satellite-based monitoring during the supervision portion?
We would challenge the supervision, the satellite-based monitoring during the supervision portion for several reasons, particularly the Court of Appeals' opinion leaving that in place. I think there are several principles of law that the Court of Appeals ran afoul of in doing that. I think we talked a little bit earlier, or Mr. Finarelli did at least, about the purposes of this program. The state's consistent position, during all of this SBM litigation is that this program is designed to prevent and deter sex offense recidivism. In fact, I think the Grady 3 opinion notes that during oral argument, counsel for the state was asked directly, what is the purpose of this program? And counsel for the state conceded, in all candor, said the point of this is to prevent and deter sex offenses. So the majority turned SBM from a tool to prevent and deter sex offenses into a tool to enforce compliance with post-release supervision terms, which if you look at the testimony in this case from the probation officer, the post-release officer rather, the evidence on that point is highly equivocal. I mean, it basically boils down to speculation and conjecture. Possibly we would have been able to been alerted to his travel to the different county had he been monitored. It is possible. Even the DA in arguing to the judge acknowledged it. The direct quote from the record is, "We don't know that it would have prevented this crime or not, but the possibility is that it could have." And that's just the evidence about the specific period of post-release. There is nothing in this record at all about the efficacy of this program beyond the period of post-release, where all we know is that Mr. Hilton will be monitored by some people in Raleigh. How that works, what kind of contours the program has at that point is completely silent here.
Now, your colleague in the prior argument conceded that satellite-based monitoring was not as intrusive as being on parole, probation. Would you also concede that?
I would not, with all due respect to my colleague. I think if you gave someone a hypothetical choice, hey, a probation officer can search through your house at any point over the next 5 years whenever they'd like with minimal notice, or hey, we're going to strap this monitor to your leg, which is going to functionally become a part of your anatomy for the next 5 years and record and catalog your every movement over the next 5 years. Which would you like to choose as the less intrusive option? I think that would be a difficult choice. And I think plenty of reasonable people could say, just have the probation officer come to my house and search my stuff whenever they want. Because
so is it your position then that Sampson does not control SBM?
In terms of it being a special needs search?
No, Veronia is the special need. Sampson is parole probation.
Yeah.
Probation parole.
Oh, for sure, if you were on post-release, your expectation of privacy is lower than it would be if you are a free citizen. No one would dispute that. It is a more interesting question, and one that is not really precisely before this court, about whether that diminished expectation of privacy is outweighed by the evidence that SBM is necessary to accomplish a legitimate government interest. As we keep coming back to the refrain over and over again, there's no evidence this program does anything, and there's certainly no evidence in this case that the program does anything, particularly after the point of post-release, but even during the period of post-release. And so, you know, I will concede all day that someone has a diminished expectation of privacy during their period of post-release supervision, but that doesn't change that the program itself is unconstitutional, at least as applied in this case, given the state's failure to meet its evidentiary burden.
And again, I want to be clear. So it's unconstitutional during the supervision period, and it's really, really unconstitutional because of the lifetime aspect.
Yeah, I think that's fair, Chief Justice Newby. Without being flippant, I think that when you have a situation where someone is not under any post-release supervision at all, they have the same expectation of privacy in their location and movement that you and I would have as free citizens. And so therefore, you know, you have a search that is unconstitutional.
So again, I'm looking at the period of supervision. It's your position that even during the period of supervision, satellite-based monitoring is unconstitutional.
That is our position, but in this case, Chief Justice Newby, it is almost beside the point, because as I think Mr. Finarelli noted, and I may have noted earlier, as a condition of post-release supervision, mandatory, I agree with Mr. Finarelli's reading, it is a mandatory condition of sex offender post-release that you submit to satellite-based monitoring, and that the validity or constitutionality of that condition of post-release is not part of this case. Mr. Hilton has not, and frankly cannot, in the context of this appeal from the SBM order, challenge the condition of post-release about sex offender satellite-based monitoring. He would have to file a motion for a declaratory judgment or some other vehicle that is just simply not before the court. So I guess my position is the Court of Appeals erred in limiting the statute, but it's almost beside the point because there's this condition that exists anyway. And really what the Court of Appeals did was legislate in this case in limiting the scope of the order to the period of post-release. It's one thing, and there is a severability clause in the session law that created the program, but it's one thing to strike the language for life. It's entirely another thing to strike the portion that says for life and then basically write in, you know, but it's okay during the period of post-release or for so long as the defendant is on post-release. I mean, you have to add to the legislation in order to accomplish the result the Court of Appeals reached in this case. And
Mr. Grant, if I understood Mr. Finarelli's argument in his brief, and he's got time to correct me if I've misread his brief, I understood him to say, in effect, that the outcome that you just described and that you described in your brief wasn't what he was arguing or what the Court of Appeals did, in that it, in essence, by striking the words for life, left it with the trial court essentially to determine the duration of any satellite-based monitoring after the conclusion of post-release supervision. If I've misunderstood his argument, he'll correct me. But assuming that that's his argument, what's your response to it?
Well, assume that is the argument, that they didn't leave it up to the trial court. The Court of Appeals affirmatively said, the Court of Appeals didn't strike the language for life and then remand to the trial court for determination of when SBM would be reasonable. The Court of Appeals struck the language for life and then sua sponte made what is in essence a legislative determination about when SBM is reasonable, and then engrafted that onto not just the statute as it pertains to Mr. Hilton, but really, because the Court of Appeals opinion is precedent, on every future case. And that is, in essence, legislation. So I guess our position, Justice Ervin, would be that that was improper. Now, and you raised the question about legislation, and I do want to draw something to the court's attention, we filed the memorandum of additional authority on Friday morning. Our General Assembly recognizes, in light of the Grady 3 decision, that there are problems with this, not just the recidivist, but really the entire satellite-based monitoring regime. Senate Bill 300 is pending in the House right now. It has already passed the Senate, my understanding, and it makes fairly radical changes to our satellite-based monitoring regime. It is basically designed to try to mute or counteract the constitutional problems that the court held are endemic to the satellite-based monitoring program in Grady 3, or at least implied are endemic to the satellite-based monitoring program. The legislation narrows the recidivist category to include only felony offenders. It caps SBM enrollment at 10 years, so 5 years after the post-release period. It mandates a risk assessment in every case. It makes a legislative finding of efficacy, which kind of goes to your point, Chief Justice Newby. This legislation would include a specific legislative finding of efficacy. And I'm sure we will discover at some point in the distant future, if this bill becomes law, whether that is sufficient. And it provides, I think, interestingly enough, too, it also provides for a judicial review mechanism outside the scope of the parole commission. It actually scraps that whole parole commission process and instead provides a specific statutory procedure for an enrollee to petition to a superior court judge to either remove him from monitoring or to limit the scope of the monitoring to a more limited search. From what I gather, something like geofencing, where particular areas would be off limits and would alert authorities, as opposed to the general cataloging of location data that the program currently effectuates. So our General Assembly is hard at work here trying to rectify the problems with this statute. It is really, the civic process in action. This court has identified constitutional issues with this program, if not explicitly in Grady 3, certainly by implication. And the General Assembly is in the process, pretty far along in the process of responding with a comprehensive bill to try to address those issues. And on we go. So, even I think the General Assembly realizes that there are some serious infirmities with this whole regime, regardless of the argument that Mr. Hilton is making in this particular case as it pertains to his as-applied challenge. These issues kind of persist throughout the entire program, as we've been discussing. I do want just to briefly, with the very limited amount of time I have left, touch on our general warrants argument in our brief as appellant. Not only, again, this court doesn't have to address that issue because it's our position that this violates the Fourth Amendment, but, our state constitution reminds us that a frequent recurrence to the fundamental principles is absolutely necessary to preserve the blessings of liberty. And one of those fundamental principles is the prohibition on general warrants contained in Article 1, Section 20. This language, basically unchanged or very slightly changed, goes back all the way to the year of the Declaration of Independence in our state constitution. And what is a general warrant? Well, given that our state constitution is a legal document, just like a contract or a statute or case law, it's instructive to look at the original public meaning of general warrant at the time of the founding, to get a sense of what the contemporary citizens and the framers were worried about when they enacted this provision. The general warrants of colonial times were, in essence, orders authorizing indiscriminate searches of peoples or places without particularized suspicion, and gave agents of the Crown blanket of authority to search when and where they pleased. Totally unlike modern warrants, which require specificity, both as to time and place, but also as to items that will be searched and people who will be subject to that search. Admittedly, SBM is a new technology and would have been utterly inconceivable to the founding generation, but just because technology is new doesn't place it outside constitutional protections. The First Amendment applies to television and radio and the internet. And the Fourth Amendment applies to GPS and thermal imaging technology, as Justice Scalia explained in his opinions in U.S. versus Jones and U.S. versus Kylo. So the principle contained in the General Warrants Clause has effect today. It lives. It has import in our modern world, so long as it is viewed with an eye towards the original public meaning of the General Warrants Clause. And the Court of Appeals has written eloquently in the Gordon case, which I think is pending before this court and has yet to be argued, about the similarity that these SBM orders bear to the original general warrants of the founding. The sort of government overreach, again, this is not punishment. Bowditch decided years ago that this is not criminal punishment. This is a civil regulatory scheme that is dispassionately trying to accomplish a government interest in preventing or deterring sex crimes. Given that it is civil, and given that it is not punishment, this sort of overreach that SBM authorizes would have been caused the founding generation great distress in all likelihood. I mean, the state can monitor your location everywhere you go for the rest of your life without probable cause or any suspicion that you're committing a crime. They can do it from a desk. They don't have to go anywhere, and they can learn a whole host of information about you by virtue of your location. I think Justice Alito and Justice Sotomayor both had separate concurrences in the Jones case extolling or explaining this principle. So we would argue that in the alternative, this is a general warrant and this is a facial challenge that SBM orders always and everywhere under the current statutory regime are general warrants, and that is a separate and alternative grounds for affirming but modifying the opinion of the Court of Appeals below. We would ask this court to affirm the opinion below to the extent it holds post-release supervision period of monitoring to be unconstitutional, and modify it to reverse the portion saying that it is constitutional during the period of post-release. So unless the court has any questions, I would simply conclude and say thank you.
Thank you, counsel. We'll hear from the state.
Yes, I think the first point I would make is I'm still not entirely clear, and maybe Chief Justice Newby, you shared this confusion, whether what defendant is making is an as-applied challenge, a facial challenge, or both, putting aside the general warrant discussion where he just mentioned it's facial, the challenge is facial in that nature. Several times in response to the court's questions, Mr. Grant has said that this SBM is unconstitutional as applied to Mr. Hilton. In response to some of your questions, Chief Justice Newby, about is this a facial challenge or not, they keep coming back to it's unconstitutional as to Mr. Hilton in this case. I do think that part of the after effects of the Grady 3 opinion are that it would seem to invite striking down large portions of or large groups of offenders under the guise of an as-applied or a facial challenge. Now, I know that Mr. Grady made it more clearly as both an as-applied and a facial challenge. The court noted that in its opinion. But it's not clear to me exactly where the defendant is asking you to come down on the constitutionality of this program. And I don't think that this circumstance allows for, or should allow for, the striking down of satellite-based monitoring for a group of offenders. We don't know which group Mr. Hilton belongs in. Is he in the group who's committed an aggravated offense and is on post-release supervision, but then has lifetime thereafter? Is it facially unconstitutional now? Mr. Grant seemed to say that he's being unconstitutionally searched now, but yet also saying that they're not challenging the constitutionality of the condition of post-release supervision that he could have been and may now be put on because he's on post-release supervision for a different offense than he was before. So I would point out the dangers of expanding the scope of whatever remedy the court may fashion here if you are going to find that it is unconstitutional, whether based on Grady, based on an independent analysis building on the Grady framework or something different, there is a caution in expanding the scope of that unconstitutionality determination beyond the scope not only of the request of the defendant here, but how it would apply to other defendants who will say, no, I'm in that category. I was convicted of an aggravated offense. It's not the same one as Mr. Hilton, but I'm finished my period of post-release supervision. So therefore, I can use this to say it's unconstitutional as to me too.
Well, isn't the nature of the problem you're identifying true of all Fourth Amendment reasonable searches issues? So whether you're talking about whether it's reasonable to drug test high school athletes or any other Fourth Amendment type analysis that's required, there's always a question of the Fourth Amendment always requires a reasonableness as to the person that is trying to be searched, but that person often is going to be similarly situated to many other people. So isn't the challenge, the uncertainty or the lack of clarity that you identify really a function of the nature of a Fourth Amendment constitutional protection inquiry?
The short answer, no. I think the longer answer is, I don't know how you separate just the Fourth Amendment jurisprudence and a decision of this court having some precedential effect on whatever circumstance is before it. The reasonableness, and I do think it comes back to the scope of the request for relief. If what Mr. Hilton is saying is this statute is unconstitutional as applied to me, my circumstances make it unconstitutional, but I can't speak for all of the other people who might be in my category, whatever that category is, that it's unconstitutional as to them too. And in order for it to be a facial challenge, you have to find that it is unconstitutional in every application for every person subject to it. I know this was part of the back and forth, both with your majority opinion and Chief Justice Newby's dissent, as to the effect of the scope of the majority's holding. And so I would just highlight the fact that if you are going to, I don't think it's just because it's a Fourth Amendment reasonableness analysis that you have to go to the extent of enjoining, as you did in the Grady 3 case, the application of the satellite-based monitoring program to some category of offenders that you may fashion or identify. The mandatory, I think one of the other points that I would go back to from Chief Justice Newby's questions, the unconstitutionality, at least the arguments that have come thus far, the unconstitutionality allegation is that it's lifetime, not that there isn't some basis for satellite-based monitoring under some circumstances. If they are making the true facial challenge that it should be unconstitutional for any offender under any set of circumstances, lifetime, term of years, during post-release supervision, after post-release supervision, they need to make that argument. It hasn't been made in this case. And I don't know what the way to do it would be other than through some sort of civil action to establish the unconstitutionality of the statute. That's the complication of considering this a facial challenge in the context of a single offender with a particular set of circumstances that must be analyzed. As far as Justice Morgan, your question before about the severability, I just wanted to go back to that to make sure I was answering it. The excision of the for life language from the 14208.40 capital B subpart C, that excision does not make the statute unconstitutional. As we pointed out in the brief, it may make it confusing. It may make it where there is a lack of guidance for what the amount of or length of satellite-based monitoring should be. But it isn't unconstitutional to cut the language of life off of the end of that paragraph. If you did, you are simply saying, which the legislature has clearly indicated, that if you are an aggravated offender, a sexually violent predator, or have committed statutory rape or statutory sexual offense, you shall be getting monitoring. The question then becomes, how long do you get it? And that's where the reasonableness determination comes in. I think there has been some conflation of the point that the way this statute was designed, and because until Grady v. North Carolina and the US Supreme Court's decision in 2015, no court in this state had ever interpreted this to be a search under the Fourth Amendment. So the statutes weren't written, I believe, contemplating a Fourth Amendment analysis. It wasn't determined that a Fourth Amendment analysis was necessary until 2015. And then after 2015, the Court of Appeals imposed upon the state in the Morris and the Blue case the obligation to prove that SBM was reasonable, to essentially initiate the Grady hearing and to initiate that analysis. So the history of this statute still reflects, however, that the idea was that those more serious categories, and I say that not to diminish those who are victimized as minors and for offenders who get term of years sentences or term of years monitoring enrollment orders, but for aggravated offenders, sexually violent predators, and statutory rapists, statutory sex offenders, those the legislature have said are more serious. Now, you're simply ordering, if you excise the for life, the length of time. At that point, the court goes through the exact same analysis that they do for the term of years offenders, where there's evidence that must be taken. There is perhaps a static 99 that can be ordered. There are mechanisms already in place in the statute in order to effectuate that analysis to determine constitutionality and how long that period should be.
Would you acknowledge that the efficacy of satellite-based monitoring in protecting the public and preventing offenders from offending again might be different in different individual cases, so that for an offender whose pattern is to lurk outside elementary schools and pick up children, being able to monitor where that offender is could be very helpful in protecting the public. But for an offender whose crime takes place in his own home with children living in that home, that knowing that he's in his home tells you nothing about whether or not he's able to reoffend. So isn't it possible that the Fourth Amendment calculus on the reasonableness of imposing satellite-based monitoring could differ depending on the individual characteristics of the offender?
Yes, I think that factors into the totality of the circumstances test. And I think conversely, that's what mitigates against a striking down of the entire statutory scheme as unconstitutional. If you are taking the individual circumstances, whether it's of the type of offense, whether it's the offender's risk assessment, whether it's the offender's post-release conduct, they are, for example, ignoring terms and conditions of post-release supervision or probation, or they are committing additional offenses that are not necessarily sex crimes, but indicative of issues that might require monitoring on some other grounds, that those do factor into the analysis. And that's the difficulty with categorically saying this is unconstitutional in all applications for all offenders under every circumstance. Now, again, that's different than the challenge that Mr. Hilton seems to be making today, which is it's unconstitutional as to him. And I know that the court is aware of what that analysis requires, but I don't think that excising the for life language really does it certainly does no constitutional damage. And Whether it creates a confusing statute or not is not grounds to make it unconstitutional. And unless there are further questions, I don't have any additional issues to raise with the court. So thank you very much.
Thank you, counsel. Thank you, everyone. Madam Clerk.
Oh, yes, oh, yes, oh, yes. The Supreme Court of North Carolina is now in recess. God save the state and this honorable court. All right.